It is contended that the trial court believed the evidence of PW and convicted the accused. Further, the reasons assigned by the learned session judge are not sufficient to base the conviction against the accused. PW identified ornaments recovered at the instance of the accused. The same does not belong to the deceased, but during the course of investigation, no one has stated that the deceased was in possession when she left her home, unless it is conclusively established that the seized articles were recovered from the possession of the accused and prior to death of the deceased. They were on the person. The accused cannot be held guilty of the alleged offences. Further, it is not possible to establish the offence of murder in the absence of material particulars and recovery as contemplated under Section 27 of the Indian Evidence Act. The trial court failed to appreciate the said fact and passed the impugned judgment which deserves to be set aside. Per contra, learned High Court contended that the trial court had considered the evidence of PW who lodged the complaint and in whose presence was drawn. The owner of the house where the accused and his wife were residing has stated about the seizure conducted in his presence and the seizure of material objects such as mobile phones and a cheat from the house of the accused. He has stated about the seizure conducted in his presence and he has stated about handing over to the police at the instance of the accused. He has stated that the police conducted a seizure in his presence. It is contended that the prosecution proved the homicide death of the deceased, and in this regard the prosecution examined and his oral evidence is supported by a post-mortem examination report. The medical evidence is corroborated by FSL report and the evidence of scientific officer who has corroborated the oral testimony of the medical officer. Hence, the trial court, considering the last scene theory, motive, evidence of seizure, FSL report and the evidence of official witnesses, rightly convicted the accused. Hence, she prays to dismiss the appeal. We have given our anxious consideration to the arguments advanced by the learned counsel for the parties and perused the entire material including the original records carefully. Where a case rests squarely on circumstantial evidence, the interference of guilt can be justified only when all the incriminating facts and circumstances are found to be incompatible with the innocence of the accused. The question of motive of the accused assumes importance in the case based on circumstantial evidence. Stop.